right, good morning. For those of you, I think I know everyone, right? I mean, okay, so last day. So glad you guys all made it. For this room, of course, it's the neutrals track, and I have the pleasure of introducing you to your moderator this morning. First of all, this is entitled, if you're not in the right room, please, take this time to exit the door and make your way to the right room. Other than that, let me introduce us to your moderator this morning, which is Hiro Aragaki. He's a professor of law and director of the Center for Negotiation and Dispute Resolution at UC Law SF. He previously taught at Loyola Law School and Fordham University, and is a prolific scholarly author. Additionally, Professor Aragaki is a renowned international mediator and arbitrator with JANS based out of San Francisco. I know, I could go on, but no, his CV is enormous, and he's very interesting. If you don't know Hiro, you need to go talk to him, and thanks for coming up.
Thank you for having us.
I don't know if you want to do the elegant
I will.
hop. Okay.
Okay, good morning, everyone. Thank you for joining us today. Let's start with a quick round of introductions. Maybe if I could start with you, Nicholas, and work your way over to me.
Hi, good morning. I'm Nicholas. I'm the managing partner of CMS here in the US. For those of you who don't know CMS yet, because it's not an originally a US firm, it's actually one of the largest firms in the world with a European origin. Actually, Anton, who I see here in the room, also used to be a partner at the very same firm. So it's good to see you again, Anton. Small world. I am originally from Germany, but I spent almost 15 years in Hong Kong and Singapore, and then came over here to California about 5 years ago to open the CMS presence here in the US. I do exclusively international arbitration, mostly as arbitrator, but also still a bit as counsel. The focus of my work really is on international disputes, so I'm trying to bring in that perspective a bit today onto this panel. Thank you very much.
And thanks to CPR for having me here. I'm Adriana Usan. I lead the Americas office of the Singapore International Arbitration Center. So for those of you who might not be familiar, SIC is one of the leading international arbitral institutions in the world. We work with parties from over 100 countries, and American parties are one of our top users, and American arbitrators are one of the most frequently appointed arbitrators by nationality at our center. Good morning. Thank you so much for choosing this track, and we're excited to have this conversation with you.
Good morning, everyone. I'm Paige Robinson. I run the litigation and intellectual property group at Activision Blizzard, which is now a Microsoft company after a long dispute with the FTC. I can tell by looking at the crowd, we probably have many Call of Duty players, probably more Candy Crush players. Those are our games. And I look forward to providing an in-house perspective. I have, since coming to Activision, we have quite a long docket, and I've had the pleasure of getting to mediate many, many disputes. So looking forward to the discussion.
Good morning, everybody. I'm trained as a trial lawyer originally, the U.S. Attorney's Office. Then I went to Morrison & Foerster, and I headed, in 1996, I was asked to set up our international litigation and arbitration practice, which I led for 17 years. And then I went to DLA Piper for 6 years, and I was the U.S. head of their global international arbitration practice. And in terms of mediation, I'm actually the co-author with Judge Daniel Weinstein of a chapter on mediation in the Thomson Reuters treatise, business and commercial litigation in federal courts. And I'm now on my own. I do arbitration and mediation, mostly arbitration, mediation on the mass, and also I advise clients on cross-border matters. So, thank you for coming to our track.
All right, terrific. So as you can see, we have a wealth of experience here on the panel and a lot of diverse perspectives, in-house counsel, external counsel, institutional voices, and neutrals. So terrific. Let's kick off the discussion. We'd like to make this as interactive as possible. So I'm going to have the panelists, not do any PowerPoint presentations, but simply to kind of generate a discussion among the panelists on a number of different issues. We'll do that for about an hour, and then we've reserved 15 minutes at the end for audience Q&A. All right, so let's begin then by talking about mediation more in the domestic context. And tackle a couple of questions about whether mediation is underutilized in arbitration. So Cedric, if I may turn to you and ask you a couple of questions to kick the conversation off. Why, in your experience, do parties in the domestic context choose mediation? And do you see an appreciable difference in the rate at which mediation is used in domestic arbitration versus domestic litigation?
And maybe I could also introduce international as well.
Of course,
right?
yes, of
International
course.
arbitration.
Yep.
So first, in terms of statistics, and there are no exact statistics, but for the former general counsel of the AAA, I was on a panel and asked him, what percentage of your cases that are filed in the ICDR actually go to hearing, go to trial? And he said 50%, which seems high. Adriana can talk about SIC, but they're similar. And in a civil litigation context, U.S. court cases, 1%, 2%, 5%, but much smaller number actually go to hearing. And I thought about this. Why is this? And I think it's think about how the case starts. If you have a U.S. Litigation matter, you start in discovery, right? There are like rules on, you have to get, certain waiting period, et cetera. But you're basically party-driven, and you start off on interrogatories, requests for admissions, depositions, and depositions are a mainstay of U.S. court litigation and cost, quite a bit of money. What do you do in international arbitration? You have a first preliminary hearing, and you're an advocate, you're trying to assess the arbitrators, they're trying to assess the parties, but you don't know, the arbitrators don't know much, and they set up the preliminary order, the procedural order number 1, which sets out the schedule for the whole case. And it's pretty much, you're off on your own, unless you've got some type of dispositive motion. In some cases there are, some cases there aren't. But there's no depositions, none. And it's like a dirty word in international arbitration. And I always told the lawyers in our group at Morrison & Foerster, said, you're going to learn new language. And the language is not French or Spanish. You're going to learn Swahili, something totally different, and you should put aside in your mind whatever you've learned and really start all over again. So what happened 6 months in? 6 months in the U.S. court litigation, you've had depositions, you get a feeling for what your clients, how well they do, how well the other side's witnesses are doing. Whereas in international arbitration, there are no depositions. What you're doing is you're preparing, you're exchanging documents, you're pushing forward to the point where you can, another 6 months later, you're going to be able to draft your pre-hearing briefs. You're going to have the witness declarations are going to be your direct testimony in all likelihood in international arbitration. And that takes a lot of time. It takes a lot of legal work. 12 months in, you're probably exhausted, your client is probably exhausted by all the financial expense of discovery. But you now have a better sense of what's happening, who are the witnesses, the credibility in your case. In international arbitration, after 12 months, down your pre-hearing briefs, and it takes a lot of work because you have to have your brief integrated with the declarations. The declarations are, written by lawyers, and their clients. And then the declarations refer to exhibits. So it's a lot of work. But you still had no contact with the other side's witnesses at that point. So why no mediations? And I'll talk about domestic in just a minute, but why no mediations in international arbitration? I think it's because you haven't had discovery, and this is anathema to some in-house counsel, but I think it's true, because you don't have a good sense of it, and you've spent a lot of money on the lawyer time to draft your declarations, to draft the briefs, whereas in a court case, you spend a lot of money on depositions. So, there you are, you're aimed at trial, and that's why I think the statistics show that, a large percentage of cases actually go to hearing, go to trial in international arbitration. On domestic arbitration, I think it's on a spectrum. It's in between, and in my experience, both as an advocate and as an arbitrator, it's pretty much what the parties want. In some cases, the lawyers say, we want depositions, and sometimes they want interrogatories. I mean, it's almost like a U.S. court case in the body of an arbitration. In other cases, and if you ask, one of the arbitral institutions, they'll say for domestic arbitration, well, you really shouldn't have that many depositions. If the parties want a couple, a few, then that's probably okay. And I guess in my perspective, it's pretty much, whatever if the parties have an agreement, then that's great. If not, then I'll impose something. And I guess the last question that you have is, what can you do to increase mediations in arbitration?
Okay, so Cedric, let's get to that topic a little bit later.
Okay.
But the gist of what I'm hearing from you is that depositions is a big explanation for why mediation is not used as much in international versus in domestic arbitration. Is that
right? Because
right?
You learn a lot through depositions.
Yeah, so depositions are helpful and give you enough information to be able to make informed judgments about settlement.
Right.
So it's less that you're mediating to avoid the cost of depositions. It's that depositions give you that necessary kind of predicate to be able to settle.
Right, and I don't want to sound like I believe in unbridled depositions and a lot of costs.
Yeah,
but,
okay.
They
Terrific.
do serve that purpose.
Terrific. So let's get some other voices into this conversation.
I'll start with disagreeing with Cedric. I don't think there's actually such a huge difference between the domestic and international landscape when it comes to percentage of settlement. I'm not sure about the numbers for domestic, but I'm actually quite surprised that also in international cases, more than half of the cases are not going to the hearing or to an award, be it at the HKIC, I'm sure the SIC is the same, ICC. So in my view, at least that's a pretty high number that is being settled. Whether that's being settled by mediation or a settlement agreement that's not mediated, I don't think there's really statistics on that. But I think the general gist is also in international cases, you do see a lot of settlements. So people they try to avoid, and I'll again disagree on what the reason is. I don't think it's a deposition as such, or it's the cost. In my view, it's really the costs that are driving people or in-house counsel, and I'll be interested to hear what Paige says. In my view, it's the cost that when cost and time start to sting so much, parties come to this breaking point, I'll call it, where they say, look, we need to find a solution to this. And if it's not depositions or the full-fledged discovery that US-style litigation might know, there's still in international cases something we civil lawyers still call document production. It's not a discovery, but it's also, for a civil lawyer, a very painful exercise. And especially if you try to explain that to your GC from a company that's not from the US, what on earth are you doing in document production, and why is it taking 4 months? And why is it costing me hundreds of thousands of dollars? So I think it's, I don't want to distinguish too much between domestic and international here. I think it's, in my view, the main driver is you start a case, which very often is strategic, and to put pressure on the other side, hopeful that even if it has to go through, you'll win. But at some point, GCs, in my view, take a decision. Have we reached a point, and that point, in my view, again, is driven by costs and time, that we should think about settlement. Whether it's mediation or settlement is a different story.
Great. So for you, it's the cost factor. Yeah.
I think you're both right.
Yeah, exactly. I was just going to say that, yeah.
So in my approach to valuing cases, I mean, we try to take a very evaluative approach, and the kinds of cases that are on my docket, the cost of litigating are dwarfed by the potential liability. So, you know, the cost of having to take it through the end is typically exorbitant, but you know, trying to figure out what the case is actually worth is really important. And in order to do that, I mean, we heard yesterday from our couple panels on mediation, there are times when mediation fails because you've made the right offer at the wrong time. It's too early in the case. The parties don't know their cases yet. And at least in my experience, like the typical way to learn your case is through discovery. So I think that has a huge impact on the parties and the clients coming to terms with what their risk and exposure actually is.
Well, on my end, I'll just throw in some numbers based on what SIC is seeing. So we do not administer mediations. We administer only arbitrations. But we do work closely with our sister organization, the Singapore International Mediation Center. And we created a joint protocol, which we call our protocol. So since its introduction in 2014, we've actually only had about 50 cases under that protocol, and only about a third settled under the ARB-Med-ARB. But that is not to say that mediations do not happen. So last I checked, roughly one in every 3 SIC cases actually end up settling, either through formal mediation or you know, informal negotiations. There has been, I feel like the trend has shifted a bit. Previously, there were more cases that settled, and now we're seeing more cases like what Cedric said earlier that end up actually going to a final hearing.
Interesting. So I want to push back a little bit on the illusion of the distinction that Nicholas was trying to get at, that it doesn't really make a difference between international and domestic. But isn't there, though, a sense that mediation is not being used as much in international commercial arbitration as it is in domestic arbitration? I mean, this is, you know, this is my impression, at least. And if that is true, what might be the explanation for that?
I think it is true, at least from what I can tell. In international arbitration, mediation is definitely, and that's kind of our job, underused, or not used as much. I'm not sure if it's underused, it's not used as much. And I think the reason for that is clear that parties that decide to arbitrate have already chosen a separate mechanism from court litigation. They've chosen an ADR mechanism, and they want to arbitrate, and they want to get an enforceable award. I think there's, if you go to arbitration, it's already, in my view, excuse me, a lot of education sometimes for in-house counsel, not to page obviously, but some in-house counsel need to be educated, first of all, what arbitration is and how you can enforce an award. But I think that has sunk in with most people right now, that they know if I get an arbitration award, I can enforce it basically everywhere on the world. That's a safe bet, so this is a powerful tool. Mediation, on the other hand, especially in an international context, if you ask parties from Asia or Europe, that's still in their heads is still, that's, you know, it's a nice chat, you sit down, and whatever comes out of it is an agreement, but then what if the other side doesn't comply? The fact that you, now under the Singapore Convention, you might even be able to enforce it, that it can also be a powerful tool. I don't think that has, in an international context, sunk in. It's a mediation is considered weaker than an arbitration. If you want something that you can use internationally, the New York Convention and arbitral awards trump the mediation and settlement agreements. I think that's main reason why internationally it's not as recognized.
I wonder if you think that's a misconception or if there are enforceability issues.
I think there are enforceability issues,
Yeah.
for sure. I mean, again, the New York Convention is the most successful UN convention there is, and it actually works. The Singapore Convention, no offense, it's taking baby steps, to put it that way.
There's only 20 ratifiers at this point.
Exactly. There's many signatories, but
what about consent awards? Why not structure it so that you have a mediation window, you do the mediation, when you reach a settlement, you reduce it to a little more?
And I think that's actually perfectly fine. That's what the SIC ARP protocol basically does. I've actually done one of the 50 cases where I was the chair in the arbitration, and the case did come back to us because the party didn't settle in mediation. But I think that, and we might get to that later when we talk about ARP, but I think when you provide for a window, and that can be done in PO1 to encourage parties to even think about mediation, because a lot of people don't. If you provide for a time period that parties should discuss or think about mediation, then come back to a tribunal if they can't, or if they come back and said, yes, this was a good idea, here's a settlement, we want a consent award. Obviously that works, and that is used very much also in Germany, where I come from, with the exception that very often it's not a formal mediation. People go out, they talk, they settle, and they say, we want a consent award. But so I think that the issue really is, I think parties settle quite a lot. They just don't use mediation as a tool to do it.
So, I had a proposal, I kept thinking, how do you increase the number of mediations? How do you increase the number of mediations in international? Judge, the way I got to know Judge Weinstein is he was a mediator for our client. Our client was Amway, and Amway was accused in a big class action of being a Ponzi scheme, which it isn't. We did a study of all 50 states, so they're not a Ponzi scheme. But it was a better company case. It was David Boies and Boies Schiller, and also Willie Gary on the other side.
It's
Is it on?
Mine's off.
Okay. And so our first mediation in front of Judge Weinstein.
Can you maybe use pages, maybe that might be a problem that
What was it?
turn that off.
Use my mic. Your mic might be fuzzy.
Come on, use your mic. Is this better? Okay, good. Anyway, so the first mediation, everybody troops into New York, and the first offer, to make a long story short, was $1 billion. And it was Willie Gary saying, I want to make things really easy for you, and so we got up, and general counsel, head of litigation, we went to the elevators, and thank you very much. And Judge Weinstein came out and says, no, it was bullshit. Don't listen to them. Come back in. I've got some ideas. And we sort of hesitated, and general counsel leading us and said, okay, we'll go back in. So that was the first day. And by the way, the ladies came in with mink coats, and it was a very hot day. And if you think about it, they had mink coats because they wanted to show how successful they are. That's the only reason they wore mink coats and a hot day in New York. So we had mediations, and it was like over 10 days, maybe 12 days of mediation over 2 years. And what the judge did was he said, I want to give you some homework. And he said, I want you to retain a damage expert, the other side to retain a damage expert. I will have a damage expert, and my damage expert will give your experts instructions on various parts of the case and how much they're worth, et cetera, et cetera. And so we then, instead of focusing on how much we couldn't get along and how we're litigating in court, we began focused on the expert report. And we had a series of assignments like this. And after 12 days of mediation, and we're litigating, went to the Ninth Circuit, came back down, and the fact of the matter is we settled, at the end of the day for, it's all public, $23 million, which was, and everything, at that point we wanted everything to be dismissed, which was good. And the only other thing I'd say about that is the reason we started that was the Ninth Circuit, we were on appeal on a secondary issue. There's a mandatory settlement conference, and the mandatory settlement lawyer talked about settlement. And of course, neither side wanted to settle, but the other side made a comment, in between, a lot of advocacy. He basically said, well, we wouldn't mind if, we had settlement discussions. So I called the general counsel and said, well, what do you want to do? I mean, we can ignore it because it wasn't really a big offer. And he said, well, why don't we look into it? And that's how we got into mediation. I called him up and I said, look, when I was younger, I would never have called you up like this. It would have been like a sign of weakness. Where I said, you're not going to see this as weakness. You're going to see this as, this is something we're picking up. And that's how the case resolved itself.
Terrific. So let's shift gears a little bit now to talk about what might promote more use of mediation in arbitration, especially internationally. And we have three subtopics here that we'd like to cover. The first is the role of the lawyer in this. The second is the role of the institutions, the arbitral institutions, in promoting mediation. And the third is the role of the neutral, the arbitrator. So let's start with the role of the lawyer. What are your thoughts on this? Paige, we have Paige, the in-house counsel perspective. Nicholas and Cedric can give us the external counsel perspective. Thoughts?
Yeah, I mean, I imagine that most outside counsel are taking cues from their in-house counsel on interest in mediation. I am at a company and now have a parent company that thinks of mediation as a part of the process for every case. I don't have too many international arbitrations. I have many domestic arbitrations and court cases, and would be interested in mediating any of them, even those cases where in the end you learn enough to realize this is a problem issue or a problem party, and if we settle now, they'll keep coming back. But I see the value in mediation. I have experience with outside counsel because I think I hire the best and they believe in the case. A feeling that we don't need to settle this. Like, this is a case that we should take to the end and win. But in the end, I manage a portfolio of risk. And so even settling cases that we are the righteous party in is retiring risk. And I've been trying to educate my in-house clients on how that's still a win.
Now it's back on. I think one of the interesting, conflicts of interest actually is between in-house counsel and external counsel. Sometimes they have different ways of making money. The external counsels actually make money if the arbitration goes all the way. The in-house counsel has a business perspective, a long-term business relationship, and cost control. I've already discussed that. Internal KPIs that need to be met. The external counsel needs billable hours and his team to have a good realization ratio and stuff like that. So I'm not saying external counsel are unreasonable, but the starting point might not be the same when you think about what's the best way to get this off the table. So I think, again, I'm not saying all the external counsel are the same, but I think that is something that we need to keep in mind, that external counsel and internal counsel don't necessarily have the same motivation to settle a dispute.
Yeah, I mean, I see that and I've felt it sometimes in mediation. I do think, referring back to a panel that we had yesterday, structuring your alternative fee arrangements so that you can award a bonus for certain outcomes can mitigate some of that and align incentives.
And have you used those kinds of alternative fee arrangements?
Yes.
With success. Interesting.
Yes, with success.
Wow, interesting. Let's talk a little bit about pre-dispute stepped or multi-tier clauses. You know, the ones where they say first you have to start negotiation, if that fails, mediation, if that fails, arbitration. As counsel, I'm sure you've probably drafted and negotiated some of those clauses or advised clients about them. Are they helpful in promoting mediation, do you think, or are they just a hindrance?
Me?
Anyone?
Anybody?
I'll happy to go. I'll be happy to go first. I think they can be a very useful tool, but they're also very easy to abuse. When you're, let's say, on the respondent side, I think we've all done it. It's fairly simple to stall and fairly simple to raise objections on just about every step, or when the arbitration finally starts, because a certain condition precedent wasn't met, or a certain negotiation has not lasted for the necessary time frame, etc. So you name it. There are many, many ways to abuse them. If they're drafted properly with explicit timeframes, explicit steps that need to be completed, if they're not completed by a certain point in time, you can move on, etc. I think they can be very useful. And if one of those steps, for instance, is a reasonable attempt to mediate, I think that is definitely an incentive and a helpful tool also for external counsel to say, look, we have to try to mediate. This is not going to make me look weak because it's in the clause. We have to do it. If it's not in the clause, again, I think Cedric mentioned it, looking weak is often a problem. That's in people's minds. Oh, if I propose a settlement, or if I propose to mediate, maybe the client or the other side will think we don't have a strong case, we're basically running away from it. If it's in the clause, all of that is out the door because you have to do it. So if it's drafted properly with a good structure so that it's not abused, I think it's a helpful tool.
Yeah, I don't have a reaction from experience based on whether it actually leads to more settlements pre-dispute, but I think the value is it prevents surprise, because you get some forewarning before someone sues you, and then it's published on the front page of the Wall Street Journal.
Can you hear me? Is this, you can or can't? No, let me just use that while you're I have one caveat, which is make sure you have a deadline for each step. Otherwise, it just becomes a delaying tactic, or just delays things. I do think there are cases which deserve to be mediated early on. I think there are minority of cases, but this will break the ice. Now, neither side's weak. You're both coming, and you both say, well, I have to do it. And then you'll get rid of some cases that way.
Yeah, so that's a nice segue into another question I wanted to ask you. But did you want to interject before that?
Oh, no, I was just going to add on about what Nicholas said on ARB-MED-ARB. And we believe in it. That's why we created a protocol, especially in some of the Asian countries where it would be hard to take the first step and raise your hand and to ask for mediation. But so our experience, at least with ARB-MED-ARB, but just a little bit of a background on it. So this is not the traditional ARB-MED-ARB where the neutral switches hat. So the way we designed it is you start an arbitration with the center. We constitute the tribunal, and then we suspend the proceedings. We move the case seamlessly to the mediation center. They have about 8 weeks to negotiate and try to enter into a settlement. And if they end up with a settlement, they can go back to their tribunal at SIC and have that tribunal issue a consent award, which now would enjoy near global enforceability. What we notice for those cases that do not end up with a settlement, when they go back to SIC, to the tribunal, some of the heads of claims have already been struck out. So maybe they have a better sense at that point, you know, whether some of their arguments are weak, or if there are risks in pushing forward and arguing some of those issues.
Yeah, I'll just say in the one case I did, they had actually hardened, the positions had actually hardened when they came back from mediation. But I just wanted to add that I think it's a very valuable tool. And the good thing is, and it goes back to what Cedric and I said, there's strict deadlines in it. You know, in that case where we were appointed, we received a request for arbitration, then it was handed over to the Singapore International Mediation Center. We knew exactly in 8 weeks they'll either come back and say we settled, or in 8 weeks they'll come back and say we didn't settle, please continue with the arbitration. So it was a clear timeline that I think is very helpful and can't be abused in a way that I mean, of course you could stall by 8 weeks, but 8 weeks in the context of an international arbitration is not the world. So it's actually it's a good thing.
Terrific. Let's talk about timing issues in terms of suggesting mediation as counsel, right? Is there a sweet spot in terms of the life of a lawsuit or an arbitration when you think it's most effective to propose mediation or settlement?
Well, I always appreciate, for reasons we've discussed already, being ordered to discuss mediation, because then you have cover. You're not suggesting to the other side that you believe your case is weak. But even when there's really nothing that's changed, you've completed discovery, I think suggesting mediation at a time where a key motion or dispositive motion is pending can be a great time when both parties recognize that they have risk and they don't quite know which way the case is going to go.
Well, I agree. I think if you have a dispositive motion, which can happen more frequently in court litigation, but it's hanging over somebody's head, and you don't know what's going to happen, and a judge could go either way, that's a great time to mediate. I also think, and this harkens back to what I said earlier, I think you need some discovery. You need to have some insight into what the other side's case is going to be, what your case is going to be. You don't want to go all the way to the bitter end, because at that point it's very expensive, and then it's harder to resolve it. But I think a good lawyer, a good advocate who understand, I think I have enough right now. We can open up discussions.
Well, for us at SIC, we actually amended our rules last year, the 2025 rules, where we've baked in arbitration, mediation within arbitration, so that there are prompts in different stages. So it begins with actually the notice of arbitration and the response to the notice. We invite the claimant and the respondent to actually, at that point, at that early stage, to comment on the possible use of ADR, ARB-MED-ARB, or mediation. And then again, we've now included a provision asking the tribunal to raise the possibility of mediation at the first preliminary conference. We've also made it explicit in our rules that the tribunal has the power to suspend proceedings to encourage parties to go through settlement discussions.
Yeah, let's talk a little bit about the institution's role now. We're kind of segueing into that topic. So you mentioned these new rules. Can you say a little bit also about the new SIAC rules on dispositive motions and summary adjudication? Because I think there's a nexus there between those kinds of rules that get parties to think about the merits a little bit more deeply and promoting mediation.
Yeah, you're right. So most institutions, they would have early stage tools. So for instance, you have the emergency arbitration proceedings where you need urgent interim relief. And like what Hiro said, this positive rule, so we have what we call early dismissal. So it's like your summary judgment, summary disposition. We have preliminary determination of issues. So these tools were really meant to expedite things, to make things more efficient, right? But what we've found is that it also brings parties closer to a settlement. So in our experience, what we've noticed is, for instance, when a party has gone through an emergency arbitrator proceeding, they end up actually settling 30% of the cases that we've seen that went through that. And then for early dismissal, about 15 to 20% of those cases settle after an early determination application has been decided. So I think these rules, they provide sort of natural pauses for parties to again reassess, their positions. And yeah, we have observed that it does help parties start negotiating and discussing.
If I can just add to that, I think this all goes back to what Paige and Cedric said at the beginning. The more the parties know about their case, the better they can assess whether it's worth pursuing it and going all the way. Obviously, and we talked about that in a context of discovery, et cetera, obviously the best indication to know your case is when you get certain parts of it thrown out or confirmed by by a summary dismissal, early dismissal, or if an emergency arbitrator that already renders, it's not an award, but he or she renders a decision on the dispute, so you have a fairly good indication of how a neutral person will view your case. So that's obviously the most extreme, in my view, way of assessing your case is when you have an indication of how it's going to be decided. And obviously that prompts settlement discussions. I fully agree with that. I would say one less extreme, and that's the civil lawyer talking, way to do it is for the tribunal to offer preliminary views at a certain point, at a midstream conference. Of course, and it's a dangerous field, especially when you talk to lawyers, especially from the UK, that will cry scandal immediately that you can't do it. But I think if it's done right, if it's done with party consent and everyone agrees and it's signed off, preliminary views at a midstream conference, they're preliminary, they're not as extreme as an arbitrator EA decision or a summary dismissal, but preliminary views have the same effect. They give you a very good indication of where the tribunal is going, and that, coming back to the point in time when you can settle, obviously would be a great time to think about mediation when you have such an indication from the tribunal.
Terrific. So now we're really getting into the role maybe of the neutral in promoting settlement and mediation, and one of them might be by giving preliminary views. Should that be coming from the arbitrator, the suggestion to give preliminary views, or is it something the arbitrator should wait for the parties to request that?
Well, that depends. Again, I'm sure you all know that it's a culture issue. Civil lawyers will say, yes, that's the most normal thing to do, because that's embedded in the legal system in most civil law countries. Judges, for instance, in Germany, where I come from, have to have a conciliatory meeting at the start of every trial. You have to ask the parties, don't you want to settle? And I can assist. So it's embedded in the legal culture in many civil law jurisdictions that it comes from the judge, or in this case, the arbitral tribunal. In an international context, also civil law arbitrators won't do that for good reason, because in the common law world that's frowned upon and seen with due process concerns, etc., which I share. So I think, in my personal view, even though I'm a German lawyer originally, I would say this is something the tribunal can indicate, that it's here to help the parties resolve their dispute, be it in an award or in any other way, if the parties so wish. So I think the tribunal can facilitate it. I'm not sure it should actively encourage it.
U.S. views on this topic?
I think it's very dangerous. I think it's dangerous, actually, for an arbitrator to give preliminary views. I mean, I don't see how that works very well. And even a judge, you know, a U.S. District Court judge or a state court judge can push parties to resolve a case. They probably have more freedom than an arbitrator does. But even then, I think it's very dangerous. So, in my view, you know, I wouldn't do that. Even though I may have views, you know, even though I may think, gee, this would be a great case to mediate, and if they appointed me as a mediator, took off my arbitrator's hat, I could mediate a good resolution. But I just don't see that happening. I think it's very hard to make that happen.
And I fully agree. In an international context, I would strongly advise against doing it unless you have written confirmation from both sides that it's okay, that they want it, and that they can challenge you or the award on this basis. I think if the parties want that, fine. But I fully agree with you. It's a dangerous path.
I think there's some room for it in early case management, and we're often a party who is seeking leave to file dispositive motion, so having some input on where the soft spots are, I think, are both useful for valuing the case in the arbitration context, but also deciding whether to mediate. I lost the second part of my thought, but that pretty much sums it up.
All right,
I'll give you one example of a middle ground. We once had a case seated in Japan, and both parties weren't very experienced with document production. So we scheduled a midstream conference on document production only because they were fighting for weeks over certain document requests going back and forth. And then we sat down with them and talked them through it, and it was almost like it was proper mediation, but it was a facilitative talk between the tribunal and both sides that were fighting for weeks over these document production requests. And we ended up going out of the hearing with, I think we had 48 requests on each side, 48 and 54 requests from both sides, and we ended up with one after the meeting that remained. So that really helped to sit down with the parties and offer our preliminary views on how we would decide those document requests if we pursued them to the very end, which would have taken more time and more costs.
Yeah, it's kind of like a tentative ruling in the U.S., yeah.
I remembered my thought. It was about the culture of tentative rulings in California state court. And of course, it's a little bit different because judges issue tentatives after they've seen all the briefing. But I think it's important for the parties to be able to understand what they need to convince the judge about, what's the most interesting points in that briefing.
I mean, I think this point about party consent to preliminary views is key. But I think the real issue is whether they consent after the arbitrator has already proposed that, or whether the arbitrator waits for the parties to propose it. I think that might be the more critical question on some level. So, this discussion of preliminary views, I think, really raises what's in the background here is the civil common law divide and different assumptions about the role, really, of the arbitrator. Is it even the role of the arbitrator to try and facilitate settlement? And this is really a question that I'd like to draw out. There's a well-known Germanic approach to this issue. The arbitrator is not just an adjudicator, they're also a settlement facilitator. There's lots of new writing and reports about this. The ICC Commission came out with a report on facilitating settlement in arbitration and so on. And I wonder whether even, for us in common law jurisdictions, that tide is changing, and arbitrators are now seeing themselves more as having some duty to try and facilitate settlement, and if so, what does that look like? Thoughts about that?
I mean, I'm biased. So no, I'm actually not biased. Obviously, you're right. It's a Germanic approach. It's not just a Germanic approach. It's a continental European approach, I would say. And I know to some, especially English lawyers, it seems unimaginable that German judges in litigation proceedings actually produce enforceable judgments, even though they've tried to facilitate settlements. So those jurisdictions where that's within the culture produce enforceable judgments that are also enforced overseas. So it can't be that wrong to try to do it. I do understand it, as I said earlier, I fully understand the concerns around it and the due process issues. And as Sarah Shedrick's views that in international arbitration, it's a slippery slope to do it. But to facilitate settlement, I think is a different story than to, as I said, offer preliminary views without the parties' consent, or tell them, oh, you need to settle, let's talk, these are your weaknesses, now get together. But obviously you can't force it on the parties. The thought that an arbitrator is not only appointed to see the case through all the way to the end, in any case, but to also remind the parties, if unsuitable cases, that he or she is there to assist in other ways, I think can be helpful too. And the ICC has recognized that too.
Can you give some examples of what that looks like in a more kind of continental European practice, facilitating settlement, beyond just giving preliminary views, and in particular, how that's different from switching hats to become the mediator midstream?
Well, I think switching hats is the most extreme way to do it, and I'm also not a fan of that, because you can't unsee what you've seen and unhear what you've heard. But I think facilitating settlement in a step back would be to, for instance, offer to the parties that for the next submission, you give them a list of issues that you consider relevant and that they should focus on. It's a step short of bifurcation, for instance, that you say, okay, please focus on these issues first, because I think I need to understand these first before we even get to part B of your claim. Perhaps that gets the parties thinking, right? Maybe if that's where we. So it's a fine line, and again, I think party consent to all of these issues. I would never do it without party consent, and again, it's a lot of face-saving issues as well that are involved. You need to think about where do the parties come from. How do I make sure that it doesn't offend one party if I propose something? So it's a fine line.
Well, this is maybe the American view, but I had one case, and it was very complicated, and the arbitrator pulled lead counsel aside and said, you really should think about settling. And maybe you should, I can't do it, but you should think about settling. And then everybody came back, and neither side knew, well, what was he saying? Is he saying, we're going to lose, we're going to win? And nobody made a move towards settlement, and it went all the way to hearing. But I think it's, again, I just come back to, I would not, I don't think I'm comfortable putting my cards on the table. I think it's very difficult.
I'll give you an extreme example of how you probably shouldn't do it. At the end of a hearing many, many years ago, a German arbitrator of an international panel that was appointed by the respondent actually, at the very end of a week-long hearing that really didn't go well for the respondent, the tribunal did say, so is there anything else we can do for the parties? Should we perhaps help you find a resolution to this without 2 more rounds of postering briefs, an award, etc.? And that arbitrator said, looking at his party that appointed him, bring the hay in while the sun is shining, which was quite an extreme way of telling them, okay, you're going to lose if you don't settle right now. So that's definitely a step too far.
So I should just make one, maybe an exception to what I just said, which is if you have multiple causes of action and you're comfortable as the arbitrator that you can rule on some of them, and then in the course of that, you give a partial award, so say half the claims went out, half the claims remain, that could assist the parties in deciding, okay, now I have a better, more vision, now I can decide maybe I want to start mediation, start settlement discussions.
Yeah, so some kind of proactive case management, either in the form of bifurcation or threshold issues or dispositive motions, can really catalyze settlement discussions. I think that's a really great point. I want to pick up on something that Paige said earlier in the panel, and you said something to the effect of, sometimes when the judge orders you to mediation, that's kind of a nice excuse to then, approach the other side about settlement. You don't have any fear of looking weak. Not that I think we do anymore in the U.S., but I think internationally there is still that fear of looking weak. And I'm wondering, what can the because the arbitrator can't, I would think it would be very outre for them to just order parties to mediate, but what could the arbitrator do that would be the equivalent of that? And I'm wondering, for example, is there something, would it be helpful as in-house counsel or even as external counsel for the arbitrator at the preliminary hearing to discuss mediation? And just hearing that, would that be of use to parties, maybe having a provision in their PO number 1 about mediation, or any other thoughts you have about that?
Yeah, well, I had an experience recently where the arbitrator said to us explicitly, I would encourage the parties to discuss mediate and to discuss settlement, but it was with a bunch of preamble that led us to walk away with the impression that this was not going to be a split the baby opinion. Someone was going to lose really bad. And I thought that was actually helpful. It wasn't an order to mediate, but it was a suggestion that a big decision was coming and someone would be very unhappy.
So that wasn't the prelim, that was further on into the case?
That was further on.
I see.
Yeah, we were waiting, and I suppose this leads into the other point. We were waiting for a decision on a dispositive motion that we had sought leave to file. So I think when appropriate and there are issues of law that can be handled up front, even though it's unusual to have that kind of motion practice in an arbitration, building in a schedule so that you can have some risk points along the way can help the party settle.
Okay, what about ARB, MED, ARB? So there's been a lot of discussion about mixed modes and the same neutral switching hats and so on. Has any of you had any experience with same neutral ARB, MED, ARB? Was it a positive experience? Was it a negative experience?
Well, I've had the experience with different where different people were involved. Same person, different hats. I would say no, I wouldn't do it. There are jurisdictions where it's like Hong Kong. In fact, surprisingly, the arbitration ordinance provides for ARB, MED, ARB with the same person under the condition that once the arbitration resumes, the arbitrator has to disclose all the confidential information received from the parties during the mediation, which, let's just say, I don't know how it's going to work in reality. It's nonsense. No offense to the people that drafted this, but I wouldn't do it. It's I cannot see how it's supposed to work.
Switching hats, it's allowed in Singapore. I think same rules with Hong Kong, but it's similar. You have to disclose information that you have acquired if parties decide to stop mediation and go through arbitration. But I think that's a very difficult thing to do for parties to be more upfront, knowing that that would be the consequence. So in our experience for ARB, MED, ARB, even if it's allowed for parties to choose the same arbitrator to become the mediator, that hasn't happened in those cases that we've seen. So.
Oh, so that has not happened at SIAC
No,
so far?
Yeah, so far.
Interesting.
Before meeting with this panel, I had no idea that was an option. So it sounds alarming to me.
All right, so maybe it's time for us to open it up to the audience and get some feedback and questions and comments. I see Anton has his hand up.
I think I can fill the room. Perhaps, Nicolas, you should explain that facilitating is not mediating, that you do not caucus with one party and to avoid misunderstandings here.
No, of course, facilitating settlement is not the same as meeting. Of course not. Facilitating settlement is when the judge sits in the room with both parties and offers his or her help.
Lawrence.
The panel, I think there's a lot to be said for the first preliminary conference as to the parties to the preliminary issues. They'd like to see arbitrators decide up front. They're asking about mediation because they want one on the schedule. My question is, on the step clause, if there's a mediation first step in the clause, one party though just starts the arbitration, the other party comes to the arbitrator and says, hey, party that started this arbitration didn't do mediation. Okay? What should the arbitrator do in that case? Should they dismiss the arbitration? Say, we gotta go mediate? Should they ignore it and say, you know, it's supposed to settle anyway, what does it matter? Should they just keep the case because they like being appointed, and some parties go mediate in the hall and come back when you're done? What do you think the arbitrator should do?
Terrific question. Yeah.
So this comes up all the time in the mass arbitration context for consumer-facing companies because the business model for mass arbitration, plaintiffs' firms filing mass arbitrations is to threaten tens of thousands of claims at once. And you know, in our consumer-facing agreements, we do have a step in our end-user license agreement requesting or demanding individualized notice of complaint, the opportunity to work it out. And I just, as a matter of fact, have not seen any arbitration body willing to dismiss these cases because these plaintiffs' firms are not following the EULA. So I would prefer a heavy hand because they're quite expensive once they're filed.
for our experience, if there are step clauses, the tribunals would be hesitant to, claim jurisdiction unless a precondition has been met, which is mediation. I remember a Singapore case, Hartronics versus EPI, where so it's a med-arb, so you have to go to mediation first before arbitration, and the claimant couldn't even start arbitration because the respondent didn't want to participate in the mediation. So then the respondent was saying, so let's just go to arbitration. But then, because of this condition precedent, the claimant was stuck, and it ended up going to court actually, where the court said basically you can't go to arbitration because this is a repudiatory breach of your agreement. And so, but had this been an ARB-MED-ARB rather than MED-ARB, the outcome would have been very much different because you can proceed with the arbitration.
But I think well, one solution is a pragmatic approach. I mean, if you throw the case out because of a lack of jurisdiction, and then the mediation fails, they'll come back, you'll have wasted cost and time. So my view is, whether it's an admissibility or jurisdiction issue or not, suspend the case, let them go through it. If they settle, great. If they don't, you resume the case.
If I could just add one comment on that question, Larry. I think it also might be a kind of clause construction issue too, because a lot of the time it's unclear whether it's actually a jurisdictional precondition or just a precondition before you advance through the arbitration process. So I would request a briefing on that, and then depending on that, take some action. Yes.
Had in major cases that exact situation where the panel and individual arbitrator. It's interesting. Some parties will go to court and say there's been a breach of the agreement. Most of the time, the courts, at least in common law jurisdiction, will compel those parties into arbitration. Most arbitration panels, if there's been a breach of that clause, will add that to the claims in the arbitration, rather than dismiss or allow that case to balance between the arbitration tribunal and court. It's most efficient over time. What I've seen is it's the most efficient way of dealing with it, particularly after you've taken the step. Hero, you just mentioned looking at that clause, because they can be constructed differently, those step clauses. So assuming you're past that analysis, the most efficient way, I like that word, the most efficient way to handle it is for the tribunal to assume the resolution of it as an element of disputes and arbitration proceedings.
We have a question in the back there.
Question and comment, and maybe a little off topic, but I'm a long-time litigator, long-time advocate, and almost a long arbitrator. I was tried one case in my life when I was still arbitration. What can we do as far as training lawyers to understand it? It isn't helpful to go in and lose, unless it's an insurance case where they have a certain language that you can get. But I don't understand this
Well said. Reactions?
Yeah, the one time I've been actually concerned about looking weak was when faced with a seemingly irrational counterparty whose counteroffers kept getting farther away. So rather than meeting towards the middle, every time we traded offers, theirs increased. So in that instance, I wanted to be very thoughtful about proposing more offers.
Just a quick comment along the lines of this discussion, which is, seems to me it's actually the role of the arbitrator to basically constantly check in on mediation. There's both a professional reason, which is, I think, this is supposed to be helping the resolution of dispute as best you can, but also for a selfish reason, because if you want to be chosen in the future, say this guy, he may end up settling, but he was encouraging us and worked. So, what I do is I not only discuss the preliminary hearing, but I'll then schedule a status conference, perhaps more than one status conference, after the thing's going on, and especially perhaps after some discovery, et cetera. And, it's a voluntary proceeding. Mediation's voluntary. And to force somebody to go into something that they don't want to do is kind of a waste of time. So, these are usually sophisticated parties. They know what they're doing. They can settle at any time.
And can you elaborate a little bit more what you do at these CMCs? Do you broach the subject of mediation or settlement? Do you try to facilitate the settlement yourself, or what actually do you do?
So far, I
I see.
just basic, but again, it's voluntary. They're sophisticated. I'll ask them, I would encourage the parties to settle and leave it at that. And I'll ask them, do you want me to set a mediation or do you mediation? So let's say one party doesn't want to do it. So then I'll have several points within the whole process where I'm kind of approaching that. Even I'll do a ruling on something. Let's say, I encourage the parties to settle. Why not?
Interesting.
I mean, again, I want the thing to go forward so I can make extra money.
So,
Interesting.
so I agree with that, right? So, but that's as far as you can go. You can ask the parties, have you considered, resolving this? Have you considered settling it? If you want a mediator, I can refer you to a mediator. You could do that at various junctures, and I think it helps, helps break the ice, right? Because you need sometimes, you're as an advocate, you're battling back and forth, and that's all you think about, the next motion, and then somebody says, oh wait, now do you want to resolve this case? And this case is very messy. I mean, you could say that, but I agree, I wouldn't go any further.
Kana.
I am 50% mediator, 50% arbitrator. I try to keep those separate. I tell the case manager, don't do a big case management thing for a mediation and an arbitration at the same day. But I always, at every juncture, gently raise business case for possibly third-party assistance. I never tell anybody that I'm thinking one way or another about the case. I just use my inside former inside
I think that's a great point. The mock tribunals, they're interesting in many ways. I think the first point, the most interesting point usually is when you get asked to be on the tribunal, who you're supposed to represent, right? So, right? That's the funniest point. So, okay, they pick. There you go. See, I think that's usually the most interesting point. Who am I supposed to be on the real tribunal? But then, of course, they pick you for their certain characteristics, legal background, or way you decide things. But on a more serious point, I think they're an excellent tool to promote settlement because they will, what I said earlier, they will give you a real insight into how a neutral tribunal will adjudicate your case or likely adjudicate your case. Because if you do pick a mock tribunal that is similar to the real tribunal, there's a very good chance they will decide the case in a very similar way than the real tribunal. And if they tell you you're going to lose on jurisdiction, or if they tell you, yes, you might win on liability, but you have no case on quantum, what's the whole point, right? So I think that it's a very good point. Mock tribunals, the only downside is they can be very expensive because you're basically paying for 2 arbitrations. And that's obviously the downside and also the hard part to convince in-house counsel to add to their already expensive arbitration budget a second one, which is basically the same cost again. So I think that's an uphill battle there.
But you can control that as a real question. How much? In some cases, I think it's all of the things right before the hearing.
Right.
And that's the whole arbitration.
Yeah.
But in other cases, I think giving part of it, hard to know how much is too much. There's Goldilocks solutions somewhere there. But yeah, you're right.
There's also AI tools now that you can use to analyze the transcript on how the arbitrators feel about you and
I'm actually really curious about your midstream CMCs, Kana. I'm going to follow up with you on that offline. But can you just describe a little bit more for us what you do in those CMCs? So is it basically like a discovery status update, and then you kind of somehow steer the conversation towards possibility of settlement? How do you do that?
I try to pick times in procedural timetable, any case, where it might make sense to close the discovery, disclosure, sorry, close discovery or disclosure, or I'll make it, even based upon case for disclosure. And it's always make it sense to the parties because it is expensive for them to get there.
Yeah.
So we have a conversation, and I tell them I'm just trying to follow along with the case, and the purpose of these status conferences is not necessarily anything other than assessing the progress against the procedural timetable. So that's the bottom line. But I have had some objections to this process because some arbitrators think, when they share, they wonder if it encourages parties to have to leave. Because if they know they have a chance to speak to the panel, maybe things that they would have done can be confirmed from their own problems without other cases going, they'll fight for it if they know they have a chance to fight it out and it's in arbitration. But I try to counter that by having what I call an ironclad meet and confer obligation in all of I'm not sure, all the lines, so it's just, to answer your question, it's bespoke. The general purpose of it is benign. I'm just assessing progress against the procedural timetable that I try to put the conflict with that as rational and that's the case in progress.
Terrific. Thank you, Kana. Our time is really up. Can we entertain one more question?
Cutting into your coffee prices.
Okay, maybe one quick question.
No, I was just going to, I do exactly the same thing as you do, Connor. I wanted to just applaud that, except, good start makes for a good finish. I call that initial conference, not a preliminary conference, but initial management conference in which we go through with both parties and counsel those details. And every 60 days, that status conference, or you call it, forget what you call it, Connor, it
So,
Excellent.
so the only, I think that's a good idea. The larger the case, then it's actually economically makes a lot of sense to have more check-ins. And if there's not much at stake, then it's harder at that point.
All right, I feel I have a duty now to terminate the panel. Thank you all so much for joining us for this session. Thank you.
So Reg, I remember our case, and actually, right. You